Ready. Mr. Naganand, over to you, sir.
Mr. Harry Doll, respected Professor Rao, and my prospective clients. It's a pleasure to be here amidst you this morning to discuss some provisions of the new legislation that is on the anvil. I was just thinking to myself what I would say. I have made a presentation which is a very detailed one, which looks at every single clause in the bill that is now before Parliament, and it is interspersed with number of comments in red color. But for sheer want of time, I'm not going to take you through that. I expected that it would happen like this. So what I've done is I have made a kind of a mental summary of the major areas that have undergone a change or are going to undergo a change. I looked at it from a perspective. See, whenever there's a new legislation which is on the anvil, there are a number of issues which all of us hope would be there in it. And the users of the legislation find there are a number of problems with the legislation, and these issues need to be tackled. But fortunately or unfortunately, the ministry concerned, the law ministry, the parliamentary process does not allow us to engage with them prior to that stage, because everything is, quote unquote secret. They don't want to talk to anybody and openly tell them, look here, we are proposing to do this. What are your views on this matter? Is this good? Is it bad? No, that kind of an open discussion not possible. Just going on submitting representations after representations. We know what happens to all of them. Like Janata Darbars, when the Chief Minister or the Prime Minister receives those representations, they just go follow a particular channel. So I think it's something to do with that. So with that in mind, I have scrupulously avoided saying anything about the various measures which needed to be put in the bill, because I'm not going to talk to you about it, because there are a million things that we can talk about it. So I have confined myself to looking at what exactly does this legislation hope to do, or what is its object. I think if you put the heading in a capital letters, then I think I would call it Reform Stage 3. That would be the heading for the bill which I would give. Reform Stage 3. It's trying to achieve some major reforms. Is it good? Is it bad? I think this august audience is going to deliberate that, look at it, and give critical comments, and hopefully before the bill is actually goes through the legislative process in the Rajya Sabha, probably they would hear your voice somewhere. So in this reform process, the major thing that we see is unbundling of what was supply into two things, supply and distribution. Namaskar. Supply and distribution have now been bifurcated into two different things. Now, there are certain incidental, we welcome the Honorable Minister, and please welcome him with an applause. The distribution process, unbundling, is a repeat from the old electricity board methodology. When the first Reforms Act in Karnataka, as you all know, we were one of the foremost reform states. In 1999, we had the legislation. The Central Act came in only 2003. And therefore, in Karnataka, the reform process started earlier. The Electricity Regulatory Commission was set up earlier. And the transfer of the undertakings from the board to a homogeneous large company called the KPTCL, which was handling transmission, distribution, everything came. Thereafter, the distribution companies were formed. Now, the next stage is bifurcation of the distribution system, as we now call it, distribution, into supply and distribution. So the supply is going to be the link between the transmission company and the distributor. The role of the supply company is to take the power from the transmitting company, which would in turn take it from the distribution company, and the supply company would give it at a point of time where it is ready for distribution, and the distributor's role is only interface and interact with the ultimate consumer or the retail user of this power. This is one major aspect. I am not going to touch I have indicated to Mr. Dahl that subject to time being available, I am trying to come back and join you as part of the audience, and if there is still time in between all your deliberations, I will try to go along and take you through some of the amendments and what the impact is, subject to availability of time on your hands, because you have a full agenda, I see. You are going to be here till 5:30, and each session is more interesting than the other, and they throw up number of issues which merit a very detailed examination, and I see that there are a number of very eminent people, very experienced people who are going to be talking about it. The next aspect is tariff freedom. Now today tariff is fixed by the Commission. The new concept of a band that is fixed by the Commission. The rest of the actual rate at which it is to be supplied is left to the distribution company. A very important facet is the phasing out of cross subsidies. We know what a big problem the cross subsidies have been, and how are they going to phase it out? Is it a reality? The law, you may say, we are very utopian. In Karnataka, nobody will violate traffic regulations, so we'll abolish all traffic courts. You can make a law like that. But we all know that that is going to be an empty law, and it's never going to be enforced, because there will be violations and we do need courts. So the law has to be somewhat realistic. Instead of saying that they will phase it out, they must find ways and means of how they are going to do it in a country like ours. Because the minute you say that the electricity, the agricultural sector is not going to be given any kind of price subsidization, what will happen is today the burden of the state on Karnataka, I guess, is about 7 to 7,500 crores in 1 year. The minute you remove this, it's going to be much higher than that. So whether the state can afford it is a question. Open access reforms, some of them have been made. The same example holds good to say open access freely granted to everybody. How is that possible? We all know that it is impossible, and now they have carved out a different category of 1 megawatt and above, ultra large consumer, I would call them. An ultra large consumer is a right of access. Supposing we have a steel plant coming up on the coastal side of Karnataka, if they are going to import 10 megawatts of power from let us say Himachal Pradesh, how is that power going to come? They are going to bring it by ship, is it? There are no transmission lines. There are no capacities that have been built for interstate trade. Of course, number of things are being done. So to provide, to say in the law that an ultra high consumer of 1 megawatt and above has got all the freedom in the world to do what he wants, practically it is not going to work out, because it will not translate into an actual transmission of power, because you don't have the capacity. Of course, it's an utopian idea that very large consumer, we don't meddle with him. He can do what he wants and bring power from wherever he wants. See, power is not like coal, you see. Coal, at least, if you have a port, you can get it. If you don't have a port, you can get by road. But how are you going to get power if you don't have transmission lines? One other new concept which we see is they want to make power really a commodity. The Supreme Court has said it long ago that energy or power are goods for the purpose of Sale of Goods Act. It can be bought and sold like anything, though you don't actually see it, but you can only feel it if you touch the live wire. But it is still goods. That's what Supreme Court has said. Now, keeping that in mind, they want to make power trading more and more possible. They've also looked at providing a futures market for power. It's a good idea to start with. Any such development of a futures market in power is fraught with a number of things, because power is something which you cannot retain, you cannot store, you cannot keep for another good day or a rainy day or a cold day. It has to be used then and there. So consumption, production, transmission, these all things have to take place more or less simultaneously in keeping with the market situation.
Mr. Naganand,
yeah.
Can you comment for the ministers, because he walked in late, on content and carriage? Because I would like your views, with the, so minister can bear in mind. Content and carriage, and what are your thoughts on it?
No, I think, let me just finish saying what I have in mind, and then, the number of ideas that are going to come up, and so at the end of it, I could possibly supplement on that. So this is on the question of opening up of markets. What can regulators do? What can governments do to ensure that a healthy open market is available for trading in power? Because your experience will show you that at some time, even today, you can buy power at 32 paise a unit on a particular day at a particular time. But the same day after 4 hours, you cannot get it for 6 rupees also. So there are problems relating to that. How are we going to tackle that is something which should be looked at. Then one more idea which has taken legislative form now is increase in competition at every level, particularly at the distribution level. Now it contemplates more than one supply licensee, it contemplates more than one distribution licensee for a particular territory. It also provides, just like how you have no mobile number transportability, the same way customer would be able to opt and say, I don't want supplier A like we have in the telephone now, I don't want Airtel, I'm going to go to Vodafone. The same kind of a concept is something which is thought of. How feasible it is, how actually possible it is something which we should see. Generators have not been licensees. What we now see is a slow creeping regulation to touch generators in some way. One major thing that they made is, though they don't have license, their licensing has not been made compulsory for them, still a very important facet is made that it is possible to direct them to generate something and create a more generating capacity so that the state could use it. I think it is some fallout of Section 11 proceedings, which all of you are aware. Of course, that is one of the things which I saw from the publications that were given to me just now, that all the meetings that IPPA has held till now, the clamor has been to whittle down the power of the government under Section 11. Honorable Minister is here. He knows very well what the problems of the state have been and how that power has been used and how we successfully defended it before the High Court and also before the Supreme Court, because the matter is pending in some way there, saying that the state has overriding interest to protect the consumers of its own state. So there is a clamor for that. But now what they've done is they've said that a generator can be asked to augment his generation capacity so that that can be intended upon by the state whenever need arises. One major issue that arises there is who is going to bear the cost of that, because there does not appear to be any mechanism at all in this legislation as to what is going to be the effect of that augmentation. A number of eco-friendly measures are thought of. If you are in the non-conventional energy, the silver lining is maximum penalty that can be imposed on you is 10 lakhs. But if you are not in non-conventional, maximum penalty would be 1 crore. These kind of differences they have made to say that if you are in this field, you are liable to less punishment. But at the same time, some eco-friendly measures, there has been some emphasis. A very interesting concept. Is it possible to set up a special economic zone for power? Is something which throws up from the provisions. Is that what the government had in mind? Because they made exclusions from licensing requirements for special economic zone situated units. So does that mean that if a power generating company sets up a special economic zone, is free from all licensing regulations? Something which is an interesting idea which merits examination. Stiffer penalties have been suggested. Penalties have now gone up to crores from lakhs. Prosecution is also something which is contemplated, but there is a technical objection to that, which I'll tell you when I come back next, if I do come back. And the new connections, they've reduced it to 1 month. Within 1 month, a distribution licensee is bound to give supply connection to anybody who wants. Slowly we see government's power is creeping in. You know, the first process of reform measure was take away government's power and put it in a regulatory body. Now we do see government is finding the need to intervene in many matters. And one of the matters is, supposing a licensee, distribution licensee or a supply licensee, is not doing what it is supposed to do. You try to reform them, you try to tell them, but they still recalcitrant. What can be done? Government should not be powerless. So they are now given a power to say, I am recommending the cancellation of the suspension of the license of this operator, and that decision will be taken by the appropriate commission. In the interregnum, the commission, because it's a public utility, you see, if you just suspend his license, he'll have to stop business and go away. What happens to the users? So there is a provision, it's an interim measure to appoint a receiver who will step into shoes of that operator and take over the operator's powers and duties and discharge the thing. So slowly we see that some places government has felt the need to sort of intervene. APTEL has been functioning now for some years. The power of disposal has been reduced to 120 days now from 180 days. Our experience has been that generally, within exceptional cases, it doesn't happen, but most cases it does happen. There is a provision for an ombudsman. There is an in-house appeal, disputes between consumers and others. In so far as that is concerned, there has been some simplification. Instead of having separate authorities, they have said the ombudsman is somebody who can actually take charge of this. There are three aspects on which I found comments that it was not touched in this amendment bill. I'll just mention them and leave them. One is Section 11 amendment. Next is the commissions discharge a number of quasi-judicial functions. So is it appropriate or necessary to have a judicially qualified, trained person to be on the commissions? Is something which we've been talking about, because I do appear before both the other commissions, our commission, including the APTEL and courts in this regard. We do find that many times the commissions are going completely wrong because they don't have a judicial bent of mind and they don't have that experience which a judge would have. Therefore, it may be necessary. When they're given somebody the status of a high court judge, why not have a high court judge there? You could as well have it. Therefore, I think that is something which there has been a clamor for. And lastly and most importantly is effective steps for open access. I did mention this. If you have open access provisions and if you don't parallelly take effective steps to make that a reality, what is the use of having open access?